starting this this new, harassment training. There's been some new employment laws that took effect this year, and this is a very serious subject. We're not going to be doing business the way we've always done business in the past. And Mark here is going to go over what some of the changes are and how seriously we have to take this. As managers, I'm going to be, I hold you responsible to make sure that you do take it seriously and everybody in your department takes it seriously. So at this point, I'm going to go ahead and turn it over to Mark.
Donna first.
Excuse me. Turn it over to Donna, and we'll get our first set of training down.
Good morning, everyone. As Bob mentioned, this is a very important topic, and we trust our managers to oversee employees and take this responsibility seriously, and to know and to be educated about the different types that Mark's going to go over: harassment, discrimination, and so forth. But I also wanted to point out that I'm aware that you guys took the manager training on Cal Chambers last year for 2 hours. I know you sat through that. Appreciate it. The law before was 50 or more employees are required to get this training. Now it's 15. This new law also does not recognize 5. I'm sorry, my bad. 5 or more employees. I also want to point out that they don't recognize the training that we had that last year. That's why we're having this training, because there's these new laws. Again, it is 5 employees. My apologies. So we are applying this to all our offices as well. And so Mark is going to be actually going to Vancouver. I also want to point out Mark's our attorney. Some of you are new. He's been with our company longer than myself, and he's been really good at making sure that he protects the company. So I'm going to turn it over to Mark.
As Donna was saying, yeah, the laws have changed, and the little, almost like a footnote at the bottom of the new law that says that all the training that you did before, we don't care, it all starts again on January 1, 2019. And so it's like a lot of companies like yours, like, what do you mean? We just did this. So we're going to have to bring all our employees, all our managers back in, supervisors back in to do it again. I thought it was every 2 years. Well, no, they just decided to, clean the slate, start it over. So I know you've had it before, which means you should be experts and be able to answer all the questions that I have, because as far as the rules go, is the training, it has not changed. So it still needs to be interactive. You need to ask me questions. If you don't ask me questions, I'll ask you questions along the way. It still needs to be 2 hours. But what we are going to go over is there have been some fairly significant changes to the California Fair Employment and Housing Act that I can't emphasize more Bob's statement that the rules have changed, and that every company needs to take the new rules very, very seriously. And types of behaviors that may have just been, okay, yeah, whatever, even last year, needs to change. And we'll get into what some of those are. But one of the key things now is that, did you get your wristband? See these wristbands here? The Pirates. Positive, inclusive, respectful, approachable, team player, engaged. Pirate. You want to live the pirate life here. And it's really important to follow that, because if you are following it, then you will not be yourselves engaging in this type of behavior. This morning we trained the employees, because the law says that not only do you need to provide the 2-hour training for supervisory employees, that there needs to be a 1-hour training for all employees. And that took place this morning. Another group's coming in this afternoon. We'll get the rest of them trained. We have people from Rockland and Reno on the line. I'm going up to Vancouver on Friday, and we're going to get those individuals trained as well. So everybody is following this pirate life as positive, inclusive, respectful, approachable, team player, and engaged. And you will see how that all dovetails into what I'm going to be talking about today as well. So with that, let's kind of go into some of the basic stuff here now that before I get into that, as Donna said, I'm the company's employment attorney. For the purposes of this training, there's no attorney-client privilege. I'm not representing you guys. I'm providing you training for this purpose. And if you have questions, which you will have questions, and if you don't ask me questions, I'll ask you questions. Pose them as a hypothetical. I don't want to say, oh, I have this employee, Joe, and Joe is doing this and this. And so pose it as a hypothetical as well. And also, what I'm going to weave in the next 2 hours as well is what I've gone over with the employees as well too, because it's really important that everybody is on the same page and working under the same guidelines, and because they now know what the expectations are, and so it's you as the managers and supervisors is to really lead by example on this. And so, first of all, let's talk about who is a supervisor. And so a supervisor means any individual having the authority in the interest of the employer to hire, transfer, suspend, lay off, recall, or promote, or the responsibility to direct them. It's pretty broad of who is a supervisor. Why does it even matter here in California who is a supervisor? Any guesses? Besides the fact that it can be quid pro quo harassment and you have to have the 2-hour training, what is California? What type of state is California when it comes to these types of laws? Any guesses? No, there's not very many people. Remember your names. What's your name?
Al.
Al? All right, so Al. Why is it really important to understand what constitutes a supervisor, and you who are supervisors to know that you are a supervisor? It keeps Bob awake at night.
Well, I can make a guess, litigation.
It is. And more specifically, California is what's referred to as a strict liability state. And what that means is this. What's your name?
Jeff.
Jeff. So, Jeff witnesses an employee making an inappropriate race-based, sex-based, religious-based comment to somebody else. Jeff just kind of brushes it aside, and you know what? Boys will be boys. Let them figure it out on their own. Is Jeff now on notice of a potential act of harassment or discrimination in the workplace? The answer to that is yes. And what does that mean for California? That means Bob is up at night worrying because it's a strict liability state. What that means is that if a supervisor is put on notice, or if a supervisor is the actual harasser or discriminator, then the company is strictly liable. Their name will appear on the lawsuit, as well as you, not if you're the witness, no, but if you're the alleged wrongdoer, it will. So it's very, very important for you as a supervisor to understand this whole notice requirement and what puts a company on notice, because it's not a defense for us to say, well, we didn't know. Well, Al knew. Well, Jeff knew. What's your name?
Jeremy.
Jeremy. Somebody knew, right? And so the big case that came out, and this is a number of years ago, was a case involving Walmart. And Walmart is known to litigate. Why? Because they have hundreds of thousands of employees, and if they just wrote a check to settle their cases, there would be a line all the way as far as you could see people wanting their checks. And so Walmart tends to litigate. And in this particular case, what happened is that in the back of their big box stores, there's a loading dock, right? And they have individuals out there that unload the trucks. What are they called? Unloaders. And so there is a manager of the unloaders or a supervisor of the unloaders at this particular Walmart store. The manager had told one of the other unloaders, because this was a lazy manager, you tell them when the trucks come in, you've been here long enough, you tell them what to do, bananas here, bicycles there, refrigerators there. And so this individual did that. Did this individual have any title making him a supervisor or a lead or anything like that? No. Did he receive the same pay? Yes. The one thing he did do, he did let the manager know who was a good employee or not. And so but he certainly had the responsibility to direct the day-to-day chores or responsibilities of these employees. So this particular supervisor, or not a supervisor, but this particular individual who could direct others, started making inappropriate sex-based comments to one of the female unloaders as well. She asked him to stop. And that really more just emboldened him. She never went to a manager and complained, but she quit and then sued. If you quit and sue, is that all right? Can you do that? Yeah, absolutely. And she felt that it was what's referred to as a constructive discharge, and that her working conditions got so horrible that she had no alternative but to quit. And so that's what she did. And she sued. She sued Walmart and the individual as well. Individual liability, we're going to talk about that too. This is do you like your house law, because you can be individually liable. So she sues, and Walmart's defense was, we get strict liability, but we were never put on notice because she only complained to this guy and he's just an unloader. And it went all the way through the appellate courts, and it hinged on the responsibility to direct them. And the court found that because he had been tasked with telling them, the other unloaders, to do X, Y, and Z, that there was strict liability. So even though no one at Walmart who was a named supervisor, the court still found strict liability. The case went forward with Walmart on the pleading as well too. And so strict liability, it's very important. It's something that you all need to know about and think about. Next is, who is an employee? So an employee means any individual under the direction or control of the employer, under any appointment or contract for hire, apprenticeship, express or implied, oral or written. So basically, pretty much anyone who comes in here and you've engaged for services. And this also includes individuals who are unpaid interns, any volunteers. You guys wouldn't have any volunteers because you'd have to pay them because it's not a nonprofit situation. But certainly also independent contractors are protected from the laws as well. So before we get to the next slide, you've all had the training last year. Let's see if you were paying attention. And so what's the first step that you need to look at to determine whether or not somebody is subject to any type of hostile work environment or quid pro quo harassment? What do you need to look at? The first thing. What's your
Tim.
Tim?
I don't understand the question.
So the question is this. So we've got Al, Jeremy, Jeff, and Tim. I'll get to the three of you in the back as well too. So the question is this, is that if somebody comes in and complains to Donna and says that, I feel like I'm being subjected to a hostile work environment, what will Donna be looking at and asking a why question? And what is the first thing that you need to look at? Okay. All right. So I'll just jump to it then. So the first thing you look at is whether or not the individual is in a protected category. And the reason why that is that the law protects individuals who are in certain defined protected categories. And when we get into the definitions of hostile work environment and what it constitutes, you will hear me say that that is one of the most misused phrases out there, because what really constitutes a hostile work environment has to start with the first question is, are they in a protected category? And so, what are the protected categories? The protected categories under federal law. Does anybody remember what the federal law is on this? Did you guys pay attention last year when we were going through this? when they were
One
the
year
Cal
ago.
Chambers?
I mean, it seems like every category is protected now.
Well, just about, but under federal law, what's the federal law? What happened in 1964?
Besides the Vietnam War.
Well, this is, yeah, just about the same time it was going on. All right, we're going to have to, we are going to have a quiz at the end of this, and so the Civil Rights Movement. And as part of the Civil Rights Movement was the Civil Rights Act, and in particularly the Civil Rights Act of 1964. And for those of you who are history buffs, and when we first, what's that?
Isn't that the one that didn't get adopted missed it by one vote?
No, the Civil Rights Act of 1964 was enacted and it's up and running, and it was the first law in the United States that protected individuals based upon their race, their religion, their sex, and their color. There was actually somebody raised their hand. This is like, gosh, back in 2006, the first year we started doing this, and goes, you know that there was another Civil Rights Act before that in 18 something or other after the Civil War. And I was stumped. I was so mad that I was stumped on that. So I went back and did a lot of research on it, just on my own. And the individual was right. However, it had nothing to do with protections in the workplace. The Civil Rights Act of 1964, and particularly Title VII. And what Title VII does, it protects individuals based upon their race, their religion, their sex, their color, and their national origin. Those ones right there, that's it. That's all that it protects. There's been some talk over the years to amend it to include sexual orientation. Under the Obama administration, Congress did pass a resolution to change it, and then the Affordable Care Act issues blew up, and it died on the vine. And so currently right now under the federal law, sexual orientation isn't protected.
Hey, Mark, you can't do that to us. What was the one in 1800?
The one in 1800
Yeah.
that was right after the Civil Rights Act, right after the Civil War.
Yeah.
Lincoln is part of the Emancipation Proclamation,
Okay.
and it was called the Civil Rights Act,
Okay.
but it had nothing to do about workplace protections or anything like that. And it's really if you kind of digress here. If you see the movie Lincoln, they talk
Yeah.
about it in Lincoln, and it's a great movie. And if you're a history buff, it's worth going back and taking a look at it. But so that's what it dealt with. All right. So then in the late 80s, early 90s, it actually was enacted in 1990, was the Age Discrimination in Employment Act. And how old do you have to be protected? All right, I'm going to go to the back here. What's your name?
Mike.
Mike?
Yeah.
What's the age limit to be
At what
protected
age
from
does-
age
you mean
discrimination?
At what age?
How old do you have
does
to
it
be? Yep.
start? Well, I would imagine maybe 15, 16 if you are entering the
Nope.
workforce.
No. It's age. It protects people who have reached a certain age.
Oh,
Yep.
up to a certain age.
No, a
If
certain
you're over
age
a
and
certain
above.
age. Ah, okay.
And-
I would say maybe 21 then.
Nope. Up.
55.
Lower. How are you having? What's your name in the back?
Charles.
Charles, have a guess.
80.
Pardon?
80.
Lower. What's your name? And now we're going to get everyone here.
45?
Nope. Up.
What?
40. Once you reach the age of 40, you're protected, and your employees, all the employees are protected from age discrimination in the workplace. 40 may seem like an odd number, but the reason why this whole law even came about was back in the 80s, there was a major decline. It actually started in the late 70s in the auto industry and all the what are now defined as the Rust Belt cities, and a whole level of mid-level managers were wiped out. And a lot of those individuals had started working, right out of high school, 18 years old, and so by the time they worked their way up the food chain, they were in their 40s, and so they set the limit as age discrimination is 40 or above. And so if you're under 40, you have no protections based upon what your age is. Veteran status, pretty self-explanatory. Physical and mental disability, everyone familiar with the ADA? Absolutely. And so the ADA covers a whole range of different topics, from access to handrails in restrooms, to ramps, to sidewalks, everything. It also protects individual employees based upon any physical or mental disabilities. And so this is one where I'm going to pause for a moment on, because you may have an employee that says, I am so stressed out, I can't do my job. Or I have fill in the blank mental condition that's, I'm unable to do my job. And so, are you now being put on notice of a potential mental disability? This is a giant gray area that makes your job as a supervisors very difficult, because the work environment is inherently a stressful, or can be, in certain situations, a stressful environment, right? Say that you are under a deadline crunch to get a project completed or get a quote out, or or there's you need a service job needs to happen, and that you're backed up, and it's just, work can be stressful. And so whether or not that stress rises to the level of a mental or physical disability, don't know. Or whether or not, if it is a workers' compensation claim, don't know. But if somebody starts talking like that, I would reach out to HR and just kind of bounce it off them and see if you've been put on notice or not, because the law does talk about having to provide a reasonable accommodation for a known mental or physical disability. And so you may think, why are we even talking about that? Because this is sexual harassment training. This is one area where the law changed as of January 1. The law now requires us to train you on all areas of potential harassment or discrimination, not just sex harassment. And so this is why we are sitting here and pausing along the way, where in the training that you had at Cal Chambers, more likely than not was probably focused on sexual harassment only. It maybe touched on some other areas a little bit, but now the new law, and this is part of the reason why they wanted to wipe the slate clean and start afresh, is that we do need to talk about all types of harassment, all types of potential discrimination, which includes both physical and mental. And the physical one is pretty easy. I mean, you're going to see most of the time, observe somebody that has a potentially physical disability. It's the mental disabilities that are more difficult. And oftentimes, what I have seen is that some managers just, Jeff says, suck it up and get out there. Yeah, you're right. This is hard and it's stressful. Get out there. And so, one of the things that I need to do is sometimes I need to, and I probably should have said this at the very beginning, when you're doing this type of training, sometimes there are certain words that I need to say and statements that I need to, and examples. And so right now I'm going to use a word that I typically don't talk like this. What the fuck is wrong with you? Come on, get out there and do the work. I know it's hard. Or what do you make? What are you, a fucking idiot? Who makes that mistake? Have you heard that before? All right, now everyone just like this. For those of you who are listening in, our audience just went like this. They put their head down and they didn't give me eye contact. So what I'm telling you now is this, is that in the past, that type of speech, that type of behavior probably would have been, oh yeah, whatever, you know what, it's a little bit coarse when you don't want to talk like that. Stop it. And I suspect in the past Bob may have even been guilty of that. And so I certainly I changed my way as well too, but when I was a young lawyer, I worked for a giant law firm, and I listened to some of the partners just berate some associates, taking a legal book and throwing against the wall. What are you, so effing stupid? You went to law school, you idiot. Well, it's just like, wow. Unfortunately, that was never at me, but I certainly witnessed it. All of that type of behavior certainly isn't part of the pirate's life. Is it positive? No. Is it respectful? No, at all. And so oftentimes, if you go out here at the harbor, turning one of those giant container ships is pretty hard, right? Turning a speedboat is like this. Changing people's behaviors can be described sometimes as trying to turn a giant barge. But what I'm telling you now is that the rules have changed. And so this type of what can be described as more coarse type talk, more coarse type behavior is not okay. And also, whoops, where am I now? Mental disability. What are you so effing stupid? What if the individual has dyslexia? Is that deemed to be a mental disability under the ADA? Yes, it is. And so you need to be careful. You do not want, instead of saying that, you need to point out to the individual, all right, your job description says this. This is what's required to do. You keep making mistakes. Not why are you so, but you keep making mistakes, and these types of mistakes are unacceptable. And you're documenting it. We need to pay attention to detail because our quotes need to go out and they need to be accurate, right? Because if they don't go out accurate, what is it going to do? It's going to cost you guys money, right? Or when the type of service that if a service tech is out there and they've done the dial wrong, or set the gauges wrong, or they've done something like that because they're not attention to detail, well, it's not because they're so effing stupid, or it's not because what's the matter, what's your problem. The issue is that they just didn't do it right. And so you need to change your mindset on how you address and on how you manage, because those types of statements, that type of speech, not only is it not positive, respectful, or inclusive, it may take you down the road to some type of actionable harassment or discrimination under the workplace. So, yeah.
So when that employee that you just very politely said, okay, you're making these mistakes, comes back and says, well, I've been under stress.
And the question then is, you bring it to, at that point you bring it to Donna, you bring it to HR at that point in time, because it depends. And this is where managing in this work environment that we're in right now is difficult. And I'm not going to try to sugarcoat it at all, because there are gray areas in the law. And so there are cases out there that say the work environment is inherently stressful. And so just regular workplace stresses are not actionable. But say that somebody has some type of clinical depression, or some type of, there was a stressor in their life that has created some type of, that sometimes people now refer to as some type of post-traumatic stress disorder. But again, sometimes people throw that out. I got PTSD, and they really don't. And it's like one of those ones where it's kind of sort of like that acronym is almost like hostile work environment. Some people use it just because they feel that they're stressed. Other people, it may be absolutely real. And so you as the supervisors have a little of a rough navigation to determine that. So if someone says, I'm really stressed out about this, and go, I recognize it, but however, you need to have attention to detail. And when I'm saying politely, you can be a micromanager. I'll be right with you there, Jeremy. You may be a micromanager. You may be very demanding. That you may require error-free work. Is there anything unlawful about that? Absolutely not. You may be deemed to be strict. Is there anything wrong with that? No, not at all. Your workers may feel that they're intimidated by you because you are a taskmaster. You're constantly giving them what to do. Is there anything unlawful about that? Not at all. And so different managers maybe have different approaches too. There may be a hands-off manager versus a very hands-on manager. Is there anything unlawful about that? No, there is not. And so there's different ways that people manage, but what you need to do is just be mindful of some of these notice triggers now, because our legislators sit in Sacramento, and I'm a big fan of these rules. I think they're important, and because the work environment needs to be free of any form of unlawful harassment or discrimination. But on the flip side of that, it's created this an anxiety amongst managers. How do I navigate this? And so that's what I'm here to try to help you to try to navigate it, and just be mindful of, okay, what potentially, and then rely upon, you have got a great HR department, and so you need to rely upon them to whether or not to help you, navigate it through. Yes.
I can just make an observation about
Sure.
what you just said. It seems to me a lot of this is subjective and based on feelings as opposed to facts, which is very problematic for me as a supervisor. So how do I navigate that very dangerous waters? Seems like they're making laws that try to dictate how people react to somebody's management style. I don't see how that's even workable.
I'm not disagreeing with you one bit. And when you use the word subjective, the new laws as of January 1, 2019, make it even more subjective. And from my vantage point, it makes what type of advice I can give you as far as how to manage it is that engage in the pirate's life, and that's really, and also know that you have resources. But if you're uncertain about something, but what I'm saying is that you can be a tough boss. There's nothing unlawful about that. You can be, but being a tough boss, it's not saying, God damn it, you effing idiot, blah, 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 blah. You can be, all right, I need this quote done. This quote needs to be done by tomorrow, and it needs to be correct. The numbers need to be correct. The language in it needs to be correct, and we need to have it. Our deadline is tomorrow at 3. And I can't do that. And so I'm like, blah, blah, blah. Well, it's the nature of the job. There's nothing unlawful about that at all. And then if you then check in at 1, hey, how's it going? Hey, man, you're really stressing me out. You need to back off. Well, no, I just need to check in to make sure that this is happening. And then the person goes and complains to Donna, he's micromanaging me. Well, you know what? That's just the way he manages. And so, again, but it's creating this this tension. Yeah.
So,
Jeremy.
based on what you just said there, my first question was kind of in regards to what you and Tim just hit on, but does you're talking about micromanaging. Some employees may require it versus others. Does that fall into discrimination now?
Nope. So long as you're doing it for a legitimate, non-discriminatory business reason. So the individual who, they are, the quote work that they do or the service that they do, whatever, that they are going to do it perfect, or about as perfect as they can get because you've experienced with it. And so that person, you're hands off with. But this other individual may be new, or they may have, just because someone has been here 5, 6, 10 years, doesn't mean that it's really a lot of, what have you done for me lately? It's like, doesn't mean you're going to get a free pass. And so where you may have been more hands off in the past, but now you've seen more errors, that you're going to be more micromanaging of that person. When I use the word micromanagement, I don't use it in a derogatory manner at all. Some employees require it, others do not. Some managers prefer to manage under that style, others don't. And so,
If I could jump
Yeah,
in here, because this
sure.
is important, because I work with a lot of managers, and what Mark said is so important. I think everybody freaks out when they hear the word micromanage, but there's a lot of circumstances where we have to put our finger on the pulse and know what's going on out there and not be afraid of it. Yeah, there's people you can give something to and forget about it, but there's some people you can't do that. And it's okay to, get involved and keep your finger on the pulse on what's going on there. Let's not yes, this is serious, but this doesn't mean we still need to manage the company.
Yeah, totally. And that's a really good point. And if the person even says, hey, this is stressing me out that you are so engaged, and again, I use the word micromanagement not in a sense of something that it's bad at all. Because exactly as Bob said, is that you guys got a business to run. And if somebody doesn't like your management style, so long as it's legitimate, non-discriminatory, there's nothing wrong with it. And if they don't like it, then they can go find another job. I mean, it sounds kind of harsh, but I mean, that's just the way it is. You have a business to run. You have a business to run here, but which goes to, if they are having performance issues, you have to do your job as the manager. Document it. You give them warning, whether it's verbal or written. Put them on a performance improvement plan. But Donna and Patty can help you if you need assistance in doing that. But all the forms are in place and all the mechanisms there to help you do it. But that's where you protect yourself. All right, look at it. You keep copies. If they've done a quote, or if they've filled out a service report and it has a bunch of mistakes in it, keep that as an example. And it may be like you get 3 of them, or maybe just 1 of them, and then you give them the write-up. You be their manager, and if they're complaining then about what Bob's saying about you're being too hands-on, well, I'm being too hands-on because I need to be. Because I don't want to use the S word, but you know what rolls uphill, right? You managers are responsible. And so you have to make sure that you're doing your job, because you're accountable to whomever you're up to. That goes all the way up to Bob, and Bob's pushing it down too. And I'm sure he's creating what you may think is stressful, and Bob's demanding of this, and we have to do this. And so, but it's this new subjectiveness that we need to be just be mindful of it. So those are all the federal laws. California now, we have taken all the federal laws and added all these. Ancestry, religion, including dress and grooming practices. We'll get back to that one. Medical condition, genetic characteristics, marital status, registered domestic partner, sex, including gender, gender identity, gender expression, pregnancy, lactation. We're going to get into those definitions. Sexual orientation and political affiliation. So, ancestry. My grandparents are from Italy. My ancestry is Italian. I was born in Berkeley. My national origin is the U.S. That's the difference between those. Religion, we need to stop here, because this is one where, again, like the mental and physical disability stuff, now we need to train on all areas. And so, say somebody has set up a whole shrine of burning candles and incense at their workstation, and you walk in and go, you need to put all that stuff away. We can't have candles. So there's no smoke allowed inside. That's not all right. But it's part of my religion. What do you do?
But what if that offends you as an employee too?
Well,
it's a gray area, right?
Well, no, this is the easy example. The easy example on this one is that California law prohibits any type of smoke in the workplace. And so a candle falls into that. And so you could say, sorry, California law trumps that. Can't make that accommodation. But the other example is, say somebody puts a big crucifix or a big Star of David or a big, whatever, religious symbol, and it is interfering with other people's works because it's distracting or whatever. And so you do have an obligation to provide a reasonable accommodation for a religious accommodation. And so accommodation may be, all right, you don't need the giant one because that's distracting, but a little one on your desk is perfectly fine. Those are the easy examples though, but in your world it may be, some of the other examples is that somebody wants to wear a certain type of religious dress because they are, whatever their religion is, they're following the orthodox of that. And so, but you require the service folks out in the field to be wearing the CHC uniform. And so, is that okay? Absolutely. But what if they wanted to wear a headscarf or a yarmulke or something like that as part of with their CHC uniform as well too? Could they do that? Yeah, absolutely. I can see why that wouldn't be a problem. There may be a situation where, for safety reasons, as far as if there's any moving parts, that they may have to remove it, or if they need to wear some type of protective mask that doesn't seal around their face, you may need to get them a different type of protective mask. So it's not just an automatic no. Where it also has come up, and in fact we're in the middle of some litigation right now as a result of it, is taking additional time off to pray. And so could that be a potential accommodation? Well, the answer to that is, again, it depends and if it's going to cause an undue hardship or not. And so it also depends on where they are. And so for example, a service tech who has a certain schedule and they have their scheduled breaks throughout the day, to take another 15-minute break, they may not be able to complete all their tasks in the day, and you need to get that done because you have your customers. And so that may not be a reasonable accommodation. But an office person who may need an extra 10 minutes or so, that may be, and they can tack it on at the end of the day, additional, they stay 10 minutes longer, then that may be an accommodation. But then, okay, do we have to pay overtime for that 10 minutes? And so it's something on that you would just bring HR in to talk about it. But the bottom line is this: it's not an automatic knee-jerk reaction. So let's see, so that's the religious one. And so if someone says, hey, I can't do this because of, and they throw out a religion, like going, that's not a religion. I've never heard of that before. And there was a good question that came out with in the session, first of all, earlier this morning, was that does it have to be a known religion? And the answer to that is, once again, there's not a bright line test of it. Does it have to be one of the big recognized religions? No. There are some factional religions out there that it may qualify for, but if it's just something that they have made up, certainly that's not going to be the case at all.
Was there a witch?
What's that? Was there a witch? I think of Monty Python and the Holy Grail when you say that, so I'm not going to bring out any of my. All right. So.
Just reminded me it's Ash Wednesday.
So, that's right. And so, more clarification needed. So, we're now required to go into more somewhat of the definitions of what constitutes sex. Sex includes, but not limited to, pregnancy, childbirth, medical conditions, breastfeeding, lactation, gender identity, gender expression. Gender identity means a person's identification as a male, female, gender different than the person's sex at birth, or transgender. Gender expression means a person's gender-related appearance or behavior, whether or not stereotypically associated with the person's sex at birth. Sex stereotype means an assumption about a person's appearance, behavior, or the availability, or the individual's ability or inability to perform certain type of work based upon a myth. Transgender is the general term that refers to a person whose gender identity differs from the person's sex at birth. And you can read the rest of them. So, the bottom line is this. Whether or not, okay, let's talk about sex stereotype. All right, we're not going to have Donna do that because she's a woman, and you know what, you're not strong enough, Donna, so we're going to have Joe do it. Is that okay? No. So long as, Donna can perform the essential job functions of the job, you know what, there's no reason why to stereotype. You may not know this, Donna's a weightlifter, and so she can get out there and lift anything, right? Who knows? And so you just can't sex stereotype. But where it comes up even more is that, for example, Patty, I'm going to use you because you chose to wear a skirt today. Patty wears a skirt today. Did Bob send her home because she's wearing a skirt? No skirts allowed here? No, right? Say that, Jeff here decides to wear a skirt one day. Can Bob say, Jeff, go home. What are you wearing a skirt for? And Jeff says, well, you know what? I'm now, I'm no longer Jeff. I'm Josephine. And so,
I'm Scottish, actually. I have a kilt.
And so, yeah, or if you want to wear a kilt. And so and people chuckle and make light of that, but the bottom line is that Jeff has every right if he wants to wear a skirt or not. But it may be out in the field if he's a service tech. That may not be appropriate work attire. And so you may say, hey, look, you need to wear pants and work boots, and because whether or not you're male or female, that's what's required out in the field. But certainly here in the office, Jeff could wear whatever he wants so long as it is within the dress code, right? He couldn't come in wearing spaghetti straps and yoga pants because that may not be permitted. But if women are allowed to wear it, men are allowed to wear it. And if somebody says, I was Jeff and now I want to be called Josephine, or I don't want to be referred to as he, she, I would be referred to as they. And as far as pronouns go, all of that is protected. And so you need to take any type of stereotypes or biases or anything else like that and put them aside. They're not okay here in the workplace, period. And it's just a simple rule. It doesn't, however somebody identifies, it's just, you may have your own personal beliefs, and that is your own to deal with outside of the workplace, because the rules here in the workplace are different than what happens outside of the workplace. And so in somebody's home, somebody's playing field, out in front of Safeway, whatever, the rules are different than what takes place in the workplace. Jeremy?
So our employee handbook, as far as dress code, I believe it's split up into male and female dress code. Is that unlawful?
No, it's not. It's not.
Because you just said that if he wants to wear a dress, however.
It's not the dress code. It's not. No, it's not.
Okay.
It just has what is appropriate dress. It doesn't identify whether or not men can wear this, women can wear that.
Is that the okay?
Yeah, I know for certain, 100%, because I read it. I wrote it. So yeah, and so maybe one from way in the past had that, because it used to, the policies that I wrote back in the 90s said this is what's appropriate for the men, this is what's appropriate for women, and there was anything unlawful about that? No. And so dress policies are now all gender neutral, and your policy is gender neutral. All right.
So I could be put on notice for mispronouncing somebody.
Pardon?
I could be put on notice for using the inappropriate pronoun against somebody. He or she when they want to be called something else.
Yeah.
You went there.
Well,
And
I
so,
don't want to get in trouble.
yeah. So if somebody comes to you, and this is one where, and again, it's a really good question, Tim, because I have a lot of stories I can tell about this type of stuff. And there was somebody another client of ours, that they had an employee that wanted to be referred to by they. And there was one individual in particular who would deliberately continue to refer to the individual as he. And he was doing it on purpose. And there was some time, and in talking to when the individual was talking to the HR person, he goes, yeah, or they were saying, see, I just made the mistake myself, that I recognize that there's going to be some transitions and people will make mistakes along the way. I'm good with that. But this individual is deliberately doing it. And so that was not okay. And so, again, when I talked about the navigation is difficult, but the bottom line is that these definitions are all new. They are all new part of they wanted specific definitions in the regulations under the California Fair Employment and Housing Act. And so, so the answer to that is yes. All right, and then I have down here related protections. There's two types of related protections. One is that if you're associated with somebody that's in a protected category, or one of your employees is, then they would have the same protections. And association means is that, say somebody has a disabled child, somebody with autism, let's just say, and that you discriminate against the individual in the workplace because of that. That's an example of associated with. The other related protection is regarded as, and this mostly comes up with either mental or physical disabilities. And so if you regard somebody as having a disability and you treat them differently as a result, even if they don't have that disability, the law says that you can treat them like, under the law, they could bring a claim for under the regarded as prong. Likewise, I had this came up with on a religious situation. An individual manager was treating somebody who was from the Middle East, he was from Iraq, differently because and this guy was just hell-bent thinking everybody from the Middle East was an Islamic terrorist. And this guy actually, and he treated him differently as a result of that bias, but the guy turned out to be an Iraqi Christian who had actually fled the Saddam Hussein regime because he was being so persecuted. And he just happened to be from the Middle East, and he was treated like he was a Muslim terrorist. And so that is an example of the regarded as prong as well, too.
Seems like that'd be covered under bigotry.
Pardon?
Seems like that'd be covered under bigotry.
Under,
Bigotry.
well, when you say bigotry, and so it's, our words are harassment or discrimination, it would be they regarded as them being in a certain protected category and treated them differently as a result thereof, and so therefore it was problematic. All right, so there are two types of harassment: quid pro quo and hostile work environment. And so, hold on, make sure I'm following along here. And we're stopping at noon, right? Okay, so quid pro quo is something in exchange for something else. And to be quid pro quo harassment, it has to be a supervisor to a subordinate or a higher level supervisor to a lower level supervisor. And this is something in exchange for something else. So I go up to Jane and say, Jane, if you have sex with me, you're going to get a promotion. Jane has a choice, right? Jane can either say yes and have sex with me and get the promotion, or she can say no and doesn't get the promotion. Something in exchange for something else. With quid pro quo harassment, what the courts will not instruct the jury on is whether or not it was unwelcome for any type of, because the courts and the case law has said that quid pro quo harassment, when you're being harassed by somebody higher up on the organization chart than you, it's going to deem to be unwelcome. And so there is no jury instruction on whether or not there is welcomeness here, which is a big factor here. And because it's a supervisor, what is it also? Automatically, we talked about at the very beginning, strict liability. And so something in exchange for something else. Hostile work environment. Conduct based upon a protected category. There's that protected category which unreasonably interferes with an individual's job performance or creates an intimidating, hostile, or offensive work environment. There is a word left out of this definition. What word is left out? It's right out there at the very beginning, and I just talked about it. Al? Starts with a U.
I think you just said unwelcome.
Unwelcome. Oh, you said that? Okay, yeah.
Unwelcome,
Yeah, unwelcome. It has to be unwelcome behavior. And the reason why I left it out is because I really want to emphasize it and for you to think about that word on whether or not something is welcome or unwelcome or not. And so,
But Mark, if I could jump in here, and just, I think we have, because I was at the earlier class too. If I'm talking to Al and our conversation is welcome, you know, I may be using language, but you're standing there and it's offensive to you. Maybe welcome to him, but you can hear it. It's unwelcome to you.
that's exactly right. And I'm going to give a couple examples right now. So, say Al and I are old buddies, and we've known each other for a long time. We play on the same softball team, and we like to joke back and forth. And I'm telling him this joke, and it's really not an appropriate joke to be telling in the workplace. I mean, it is really offensive to race, religion, sex, everybody. Everyone's by this, what we consider a joke. And we just think it's the two of us, right? And Jeremy happens to hear it. And Jeremy, and I look over at Jeremy, and I go, Jeremy, are you offended? And Jeremy's kind of laughing and goes, no. And so this is one area of the law where a laugh may not necessarily mean it's funny, and a yes may not mean a yes, or a no may not mean no. So say that I'm a supervisor and Jeremy is an employee, right? And Jeremy doesn't want to offend me and doesn't want me to think he's a stick in the mud or anything like that. And so he just says yes. And then he goes to see a lawyer, and the lawyer says, well, you told Mark that you weren't offended by his joke because he's the supervisor, right? Well, yeah, that's why. All right. Well, was it welcome? No. Really easy to get past the unwelcomeness. And so this is one area of the law where a laugh may not necessarily mean it's welcome. A yes may not really mean it is yes. And so the bottom line is that even though it's not directed at Jeremy, does that matter? No, it's not. The unlawful harassment discrimination does not need to be directed at the individual for it to be actionable. All right. So, actionable only when the behavior is severe or pervasive. So there's a severe or pervasive standard. No recovery for harassment that is occasional, isolated, sporadic, or trivial. Take this bullet point here. I put this up here because prior to January 1, I would say with 100% certainty that that's a true statement. I can no longer make that representation anymore based upon the way that the new California Fair Employment and Housing Act is written. And so when Bob started out this morning, he said it to the employees, he said it to you, and now I'm going to say it to you again. And how the rules have changed is that what they've said now is that whether or not it's an isolated incident, whether it's sporadic or whether it's trivial, that we used to be able to file a motion for summary judgment saying, you know what, this was a stray remark, and therefore it should not go to a jury, that the judge should just throw it out. The new laws have said that a single incident can potentially go to the jury so the jury can decide whether or not that single incident or not is severe or pervasive enough, which makes it, this whole pirate's life is so important, and these laws are so important. And the reason why is this. Bob, are lawyers expensive?
Yes.
As much as I enjoy speaking with these guys, when I have to talk to Bob's all, Mark, it's really nice to talk to you again, but not really. Let's go have a cocktail sometime and have a really fun conversation. But lawyers are expensive. And what the new laws have done is up the ante even more, which means for you supervisors here now, it is really, really important. And for those of you who've I've done this training for in the past, you may have heard other trainers say this, it's your job as the managers. So here is a line right here, and this line is the sidewalk, and that sidewalk is zero tolerance. Somewhere out here, one joke, two jokes is a severe pervasive standard, okay? However, the laws now say that a single isolated incident is enough to make it go to a jury, which means you got to go through the full-blown litigation process to have a jury make that decision or not. So what your job now is, if you hear something, or if you notice any types, and we're going to get into examples, it's your job to nip it on the bud immediately. It's your job not to behave or make comments or statements or like that at all, because I can't emphasize this more, the rules have changed. And this is one where don't kill the messenger, because I'm just telling you, the rules have changed. And types of behaviors that may have been okay or just tolerated in the past are no longer going to be okay or tolerated going forward. All right, So a single harassing incident involving physical violence, yes, that's enough to be extreme. Existence of a hostile work environment depends on the totality of the situation. That is all still the law. Each one is looked at on a case-by-case basis. So what gets looked at here now? We look at the law, right? We have the first thing you look at is the actual statutes, is the Civil Rights Act of 64, which is Title VII, and it is administered through the EEOC, which is the Equal Employment Opportunity Commission, which is in your handbook policy. And then there's the state, which is the California Fair Employment and Housing Act, and the DFEH, which is the Department of Fair Employment and Housing. And so what laws will apply? All of them apply. And what will the courts, when looking at the laws, what will they do? They will apply the law that is most favorable to the employee. And so 99.9% of the time here in California, that's going to be California law. So there's the federal laws, there's the regulations behind the laws. And when I was going over those definitions of what is the sex, gender identity, all of that, those are all from the California regulations. And then there are federal and state decisions regarding the legal cases. But here at CHC, we're going to make it really easy. And this is what I told all the employees today as well, too. And that is zero tolerance. You guys have a zero tolerance policy. And I think in one of your handouts out here, I've printed out the section of your employee handbook that deals with discrimination and harassment. I went through it with all of the employees because this is what their rights are, that the company is an equal opportunity employer, doesn't discriminate against, that there's a no retaliation policy in here too, and that you may be asked to be a witness, and that if you're a witness, you're protected as well from the anti-retaliation, and that we also let all the employees know that they could go to the supervisor, you all, or if they don't feel comfortable going to Al, they may go to Jeremy. And Jeremy can't say, sorry, you're not my employee, not my deal. You don't report to me. No, Jeremy's a supervisor. He's put on notice, and a supervisor is a supervisor is a supervisor. So it doesn't matter whether it's Al's employee or Jeremy's employee. We let them know that besides HR, they can go all the way up to Bob. And so open door policy, and that in doing so, that they're protected from the anti-retaliation. We also let them, hold on one second, Tim, and then I'll get to your question. We also let them know that the company will do what's referred to as a prompt and thorough investigation. And as part of the prompt and thorough investigation, that they will be conducting just that, an investigation. And this holds for all of you as well too, is that you may go into Donna or to your supervisor and say, look, this is a hostile work environment. Well, being a demanding boss, requiring perfection, having strict deadlines, that may be demanding, but it's not a hostile work environment. A hostile work environment has to be unwelcome conduct based upon a protected category that unreasonably interferes with an individual's work environment. And so somebody may come in and talk to you and talk to Donna and say, hey, look, I want to talk to you, but I don't want you to do anything about it. I just need to vent. And your response to that is, well, it depends on what you're about ready to say, on whether or not you can make that promise or not, because the law requires the company to do a prompt and thorough investigation and into any allegation of hostile work environment or quid pro quo harassment. So I'm going to take a sidestep now too, because under the Fair Employment and Housing Act, we are required to train the supervisors on what is referred to as abusive conduct. And there is no cause of action that employees can bring for abusive conduct, but it is now, it's a policy statement made by the state of California that this type of behavior will not be tolerated in the workplace, and that all supervisors should be trained on what it is and what it means. Your company has an extensive list of code of conduct, It has a no bullying policy, all of which is encompassed in this abusive conduct. And so, abusive conduct is defined as conduct of an employer or an employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interest. A single act shall not constitute abusive behavior unless it is especially severe and egregious. Also, abusive conduct should be prohibited in the workplace. And so they've given examples of infliction of verbal abuse, such as derogatory remarks, verbal or physical conduct that somebody would find threatening, intimidating, or humiliating. I'm going to get into that in a sec. Abusive conduct has a negative effect on the victims or others in the workplace. Abusive conduct has negative consequences on the employer, reduced productivity and morale. So, you're sitting in a meeting, a sales meeting. Somebody's and you guys are the sales employees. And the sales VP goes, you know what, Jeremy, your numbers are so horrendous compared to these individuals that, you know what, you better get to it and meet your quota or you're not long for the world here at CHC. These three are all sitting in that meeting. Is that potentially humiliating?
Yes.
So, again, you need to take a step back and when I was, and particularly, some clients of mine down in the Silicon Valley when I was telling this, well, what do you mean? That's how we conduct our sales meeting. We get everybody out there and we get everybody in the room and we make them feel like shit because we think that's going to motivate them. And I'm like, well, we have a proclamation from the state of California through our legislators that say that type of behavior may be considered to be abusive conduct. And so you need to maybe rethink your approach. And so, again, Tim, what did you say that one of your concern was subjectiveness? Is this subjective? Absolutely. Is there any definition surrounding what could be humiliating, what could be deemed to be intimidating? I am so intimidated by the fact that my boss has given me deadlines to get the work done. And then, not only that, she checks in with me every hour to make sure I'm making progress on that deadline. Intimidating? Potentially. My response to that is, though, I would take that case because you have a job to do and you need to do it. So long as you're not doing it in a way that would be deemed to be abusive. But what does that mean? Again, we went over the definition. My recommendation is just you really need to think. You need to think before I don't know if you have kids or younger kids right now. I think it's called the Take 5. Have you guys heard about Take 5? It's they're teaching the kids now. Take 5 seconds before you speak. Think about what you're about ready to say. And that's kind of good advice in the workplace as well, too. Take 5 and really think about, you know, how you're delivering the message. But what I'm not telling you is, you know what? If you demand perfection, if you demand deadlines, if you're deemed to be a hard-charging, strict boss, all of that is fine. But just be mindful of the potential abusive conduct that is out there. What are inappropriate behaviors now that we don't tolerate? All right, I'm going to get into some specific examples now. And so, disparaging name, derogatory comments, sexual jokes or stories, comments about physical attributes, repeated requests for a date, belittling expressions, unwanted love letters, notes, emails, voice messages. And so the notes, emails, it can also be, and the written one as well too, so we're going to talk about those in a bit. But, so for example, Jane walks by. Jane, nice haircut, nice sweater. Anything wrong with that? It's a compliment, right? And so, now this. Jane, nice haircut, nice sweater. Pretty creepy, right? Yeah, different tone, different inflection. My eyes are going up and down. I'm checking Jane out. Same words. So tone, inflection make a difference as well too. And so you need to be, you're mindful of that.
Can't both be just as problematic depending on how the person takes it?
Well, Jeremy, that's a really good question. And so, and again, sometimes being a manager and a supervisor is difficult. Had a situation, this was probably about a year and a half ago. Individual complained that this particular manager was creepy, and he would compliment her, and she didn't like his tone of voice. Pretty much what I was doing, but I was really emphasizing it, and so what the HR did is said, "Hey, look it, no complimenting this individual at all. Let the whole department know, nothing." So and that's it. So they just stopped. They stopped it. She had long blonde hair, and I'm telling you, I can't make this stuff up. She then decides to do a radical change, gets a bob haircut, dyes it black. Totally different look. No one says a word. What does she do? She goes to HR and complains about no one made any comments about her new look. What do? That's a no-win situation. And sometimes you're just dealt with individuals who feel that they need to attention getting. I don't know what it is, but sometimes what do you do in that situation? And that's what the HR person did. We talked it through and say, hey, look, you can't have it both ways. You said that you didn't want to have anybody say anything about your physical appearance or anything like that. And now that you've changed it, you're saying everyone's ignoring you and they're freezing you out and all of this stuff. And they're retaliating against you. She used all these key buzzwords, and we're like going, no. And so fortunately they had documented everything beforehand. And so, but again, it's hard to navigate.
Hey, Mark, could you please address, because these are all managers in here.
Yeah.
And given the state of the Union of the United States, how do we address this whole political thing going on in the U.S.? Because that gets we've seen it in our own office here.
So about people's views about the politics side of it?
People get pretty upset.
So, if everyone has the First Amendment right to free speech, right? No, you don't. Not in a private workplace. And that's a big surprise to a lot of individuals. And so if you have a free speech right to go outside and say whatever you want, right? So long as it's not hate speech. Hate speech is one of the ones that's not protected. I've had individuals, when they're being interviewed by HR, I'm not saying it, I'm invoking my Fifth Amendment right. What? This isn't a criminal situation. We're interviewing you as part of a workplace situation. So, to answer Bob's question now about politics, and right now there's whether or not you can't stand the administration right now, whether or not you love the administration right now, whether or not you don't want to hear another word about the Mueller report, about the Cohen testimony, you're just through with it. Where you are on the spectrum, can you prohibit your employees from having these conversations? And if you remember, political affiliation is a protected category here in California. The answer to Bob's question is, can you prohibit that type of conversation? Yes, you can. And how do you do? Why? It's because it's disruptive in the workplace. And so you can say, hey, look we are not going to have political conversations and discussions. You can't have them if you want to draw the line there. Or you can say, look you need to be mindful and respectful of people's points of view, that everyone has a different point of view. But if it's turning out that your discussions are taking away from getting the work done, that they're being disruptive, and that certainly in the break room, that when they're on their break, they can have a discussion, so long as it is, again, you're not going to get this job, or I'm going to treat you differently because you're a Republican. Is that okay? No. Or because you're a Democrat, or you're an independent, or because you don't care. You need to take a stance. You need to make a, so no, that's political affiliation. But speech that would be otherwise deemed to be interfering with the work and the workflow and disrupting and creating, not a respectful environment, not an inclusive environment, or then you can prohibit it. And that's a great question, because that comes up a lot right now, because there are polarized views that we have, and that everyone has an opinion on it, but it can become very disruptive, and so you can
I think the
kibosh it.
managers have to take the high road. And we really have to, just like you say, this is a private workplace. Keep it to yourself and just keep everybody productive. No one wants to hear our opinion, my opinion,
Yeah, and same thing. So say somebody came in wearing a red "Make America Great Again" hat, and somebody is just offended by that, and it's disrupting the workplace. Then you can say, "Hey, look you can't wear that here." Well, it's my political expression. Blah blah blah. Well, no, this is a private work environment. No different if you were to wear a T-shirt, but you allow people to wear baseball caps, right? Mm-hmm. And so, again, you have if it is creating a work environment that is affecting the way people work, then you can say no, that's not okay. All right.
Mark?
Yeah.
So at the beginning, when we first started getting going, you were discussing contract employees, so on and so forth. So if we bring a outside contractor in to do work, say in our shop, do they fall under the same categories as the business for?
Yes, that individual, the contract employee that you bring into the shop, is both subjected to protections and can also be deemed to be an accused, a harasser as well too. And oftentimes, and I'm going to use this, that's a good example, I'll just jump to it now. Say that you have service techs out in the field and there's other trades there on the job. And one of those individuals feels like they're being harassed based upon sex, religion, national origin, sexual orientation, whatever it is, right, by someone else. What do? Do you just say, sorry, not my problem, because we have no control over what they do at ABC Electric? Can you say that? No, you can't, because you have an obligation to provide a work environment free of any form of unlawful harassment or discrimination. And the work environment includes the off-site work. And so what do? It may be you as the supervisor, the service tech manager may talk to the other manager over there. Or it may be, say it's the job owner, or who's ever engaged you guys. It may be going all the way up to Bob, and Bob's having a conversation like this, saying, "Hey, look it, your guys or your gals or whomever it is are making these statements and stuff like that." And so, it depends on how you do it. But the bottom line is, you can't just say, "Not our problem."
Right.
And Al, that has happened.
No.
I had to call the president of another company.
I'm quite certain. But that brings me back to what you were just discussing on political discussions and keeping it out of the workplace. Same would go for religious discussions, correct?
Exactly. Yeah, and so
Because we, at one point, had a contract employee come in from an outside and brought religion into discussion, and we asked him to never come back. So, it has happened.
because that's creating if it was like an employee, you would say, "Hey, look at you're certainly you're allowed to have your own religious beliefs, but by you trying to recruit or say, look at because you don't follow Jesus, you're a bad person, or because you're Islamic, the Islamic person saying because you follow Jesus, you're bad." I mean, you could have many different examples. No, you're not going to have that talk. Why? Because it's disruptive. You're affecting other people's.
Disruptive.
Yes, yeah, it's disrupting the workforce. Period, and that's fine. There's nothing unlawful about that. All right, so nicknames, hey stud, hey amigos, peaches, hey chino, all of that. No, and nicknames. Bob is a nickname. What's Bob's name? Robert, right? It's all right. Al, are you Alexander or Alex, or are you just plain old Al?
Albert.
You're Albert, all right? So is Al a nice nickname for Albert? It certainly is. Jeff, are you Jeffrey or are you Geoff?
Jeffrey.
So you're a Jeffrey, all right? And so Jeff is a nice nickname for Jeff. And so I was giving an example earlier today is that I had a case a number of years ago that was brought by an Hispanic worker, somebody who he wasn't born in Mexico, he was actually born in Los Angeles, and they referred to him as, do any of you speak Spanish? All right. So when I was a little guy, if they referred to me as Marquito, what does that mean? Little Mark, right? And is it a term of endearment? It would be kind of cute. Hey, Marquito, ¿cómo está? Would that be anything? Is that offensive at all? No, but they referred to this guy as Mexicanito. What does that mean? And so that means little Mexican. But there were the other Hispanic workers who were also one of them was from Central America, but the other two were from Mexico as well. And actually one of them was actually born in Mexico. The other one was born in Los Angeles as well too. This was a company down in Los Angeles. And he went with it, and we actually had an email where he referred to himself as Mexicanito. That was his nickname. But his performance started tapering off. He was being written up for it, and so then he brought a lawsuit. And he sued the company while he was still employed. Can they do that? Yeah, and really made a difficult situation. And in his complaint, he said they referred to me by a derogatory name, Mexicanito. And then in interviewing the guys, they're saying that we were using it kind of as a term of endearment. We liked the guy. And so, and again, I didn't go, yeah.
Okay, I got to ask a specific example right now because I have a Hispanic employee.
Yeah.
And when we're in a good mood and fooling around, sometimes I will call him Josecito.
Pardon?
I will call him Josecito. His name is Jose. And do I have to stop doing that?
Yes.
I would say yeah.
I'd say
Does that mean we can't say hijores anymore?
I
Just say Eagles, because you're out.
here's what we got to do. This, if we look backwards, I'm probably as guilty as anybody on this slide. I think we have to turn around. We got some new legislature. Let's just be extremely respectful and change our ways, and we'll be fine. Let's just like Mark said, if something happens, if somebody has to get let go, these are all problems.
Yeah.
So let's just be polite, call people by their normal name or their normal nicknames.
So another example is a second Hispanic employee will, amongst each other, one will say to the other, "Ay, Pinales." Does he have to stop doing that now?
Yeah.
Well, actually, Pinales, Pinales.
That's his last name.
That's his last name.
So what?
His last name is Pinales.
Yeah.
So one says to the other, he goes, "Ay, Pinales," every now and then.
And what does that mean?
What is?
He's just
That's
saying.
just his last name.
Does it,
Yeah, you can call him his last name. Yeah.
Yeah.
People call me Polizzi all day long. I mean,
Yeah,
it
yeah.
doesn't matter.
Yeah, if you want to say, because there may be.
Well, no, he's not. We're just fooling around. Like Jose will say something, and Pete will go, "Ay, Pinales," like that.
I think it goes back to this thing,
Yeah, that-
respectful.
Yeah,
Let's just be extremely respectful.
so your answer to respond to somebody as just their last name,
Yeah.
there's nothing wrong with that.
Put the "ay" in front of it.
I don't think that there's anything wrong with that. But again, it's what you have to. But say they may call him that because you may have, three wands, and so you refer to one of them as by the last name, or it's just two. But again, as Bob is saying, the rules have changed,
Yeah.
and how the courts are going to look at it going forward. Who knows? But it's just we have to remember that stuff that you may have thought in the past is not. All right.
Mark, real quick, 'cause I do have to go, but I have to make this statement. I understand these are political changes. What I don't want from the management team is I don't want to see managers talking together, talking about how stupid our legislature is and how stupid these laws are. because our employees hear us talk. This is to protect, I mean, legislatures are making this to protect employees. Regardless of how you feel about these laws, these are the laws, and we're going to abide by them. And I don't want to see different managers going, this is the stupidest law I've ever seen, because if it's protecting the person that's hearing you, it's a problem.
Yeah, that's a very good
You
point.
know, I can't have anybody doing that. This is moving forward. I'm guilty as hell last week going backwards. But
So,
it's a new
You're saying
world.
moving forward, these laws came in effect first of this year?
Yes.
So what's the statute of limitation if you have a
Don't ask that
disgruntled
question.
employee that just heard this morning? You know, how far back does that go?
What the laws about in protected categories, that hasn't changed.
Wait, so a question on that real quick. Who is not in a protected category? Because it seems pretty broad, and I could put myself in a protected category pretty easily.
Everybody's in a protected
There is,
category.
right, there is no one that's not in a protected category.
So we should
Depe-
just take
So
the
the
stance that
bottom line
everybody-
is this.
Right, exactly.
So the bottom line is this, is that you shouldn't treat anybody differently for any reason. It needs to be business focused, right? It needs to be, you have to have a legitimate, non-discriminatory business reason. And so if somebody's making mistakes, if somebody's not doing their reports on time, if somebody is tardy, if somebody has absent, or is absent a lot, or if somebody is just kind of sully and they bring in, there's just this, they're difficult to work with. Can you do this? Yeah, sure, I'll do it. And it just kind of creates a negative atmosphere. Can you discipline them for that? Absolutely. None of that changed, but so long as you're treating everybody the same, and that you're not singling
I'm
anybody
more
out or treating anybody.
concerned about, you know, in the past, you know, obviously, everybody in here is human.
We're all guilty. If you go backwards, we're all guilty.
I'm not questioning that. I know, I've witnessed many things, but, including myself, but say two individuals, you know, were buddies at one point, and then somewhere along the line, you know, that relationship kind of went the opposite direction. I mean, who's to say one of those here's my payday window, you know, for a conversation that
Well, that has
so-and-so
to be
had.
unwelcome behavior, remember?
Mhm.
And so what we're trying to do now, certainly whatever happened in the past, happened in the past. And so even if Bob uses the word guilty, it's not a guilt or innocent type thing, but there are certain types of behaviors that people did, what are you, a fucking idiot? What are you, this? I can't believe you're that. And so what we're trying to do is turn the ship and make sure that the type of conduct, the type of statements is that it's for a legitimate, non-discriminatory business reason. And requiring perfection, and being a hard-charging boss, being a stern boss, being the tough boss, I'm not telling you to change that at all, not one bit. But what you do need to be mindful is of how your speech is on a going forward basis. Whatever happened in the past, but now we're just going to be changing the way that people have to engage. And again, what your job as the manager to do is to manage the change. And so is all of a sudden is the switch going to go off and that people are going to, no, this is going to be a process. And hopefully everyone who listened this morning, you guys, this afternoon, and up in Vancouver will understand what's going on. But is there going to be a situation where, because it's a real stressful information, someone may go, what are you, an idiot? Yeah, that may happen. But you need to know now that there may be a consequence for that type of speech. And that's,
Well, we also need to be aware that we can do everything exactly right, but if there's an individual who's looking to capitalize on this situation one way or another.
and again, I agree with you 100%.
That's why we hire Mark.
Yeah, I agree. It's good. In fact,
I completely get it.
I'll give you an example. I was just in mid-January, less than 6 weeks ago, I was at a mediation on a sex discrimination case, and the mediator she's now all that she's doing is mediating and arbitrating cases. She is a very, very, very well-known national employment lawyer, partner at a big firm, defense side firm, but she is also goes across the country speaking on women's rights. I mean, she is one of the foremost experts on it. And we were having this discussion because this particular case, the facts they weren't there. And this individual female employee really is because it's ongoing now, because we were unable to settle it because she was asking for basically a retirement number. And the company just said no. And the mediator was saying, I agree with you, company, to say no to that because this is absolutely ridiculous. And she is one of the foremost speakers on the Me Too movement. And one of the things that she did say is that it's unfortunate that we're seeing an uptick in what are false claims because people see the big payout or a payout and they're trying to use that. And unfortunately, what it's doing is undermining a lot of this. But until, as we're going through the rough waters right now, until it all straightens itself out, it's just something that you have to deal with. And so, but what you want to make sure, and what I'm telling all my clients, and what I'm telling you guys right now is, turn the ship around and go and stay down this path of living the pirate's life, because that's a really safe place to be right now, because it is a turbulent time. And I'm not going to be able to say that there are false claims out there. I mean, you read in the newspaper some of these just eye-popping judgments that are out there. And if you're reading them, the employees are reading them as well too. And it's not that difficult to go on your phone and look at the judgments as well too. All right.
Let's gotta go. Thank you.
Yeah, see you, Bob. I'll see you on Friday. All right. So whistles, rude noises. Talking about someone's sex life. Physical now. And we started a little bit late, so can we go a little bit over 12? Okay. Physical. Standing too close, blocking, impeding, stalking, all that. So I'm going to use you, Donna, because as an example. So here, come up here. So hey, I walk up to Donna. Donna, I have this report that I need you to do, and let's see, it's Wednesday. Can you have it done by Friday at 3?
Sure.
Anything wrong with that? How about this? Hey, Donna, I have this report I need you to do, and I need it. A little uncomfortable, right? Well, did I in Donna's space there? Yes. And did I put my hand on her shoulder? Yes, I did. And so Donna then goes, and then I'm, hey, Donna, how you doing? I'm kind of petting her, and I'm touching her. Because if you notice, I talk with my hands, and I'm touching people and stuff like that. And so Donna then goes and reports to HR and says that, you know what, when Mark talks to me, he touches me, he stands too close and all of that. And so Donna then comes, talks to me. Prompt and thorough investigation. And I say, well, Donna, my name ends in a vowel. I'm Italian. Haven't you seen Italians? We talk. We're touchy-feely. This is part of my culture. What do? Too bad for me, because Donna is entitled to her space. She's entitled to not being touched by me or standing too close. And so just because somebody then claims it's part of their culture, doesn't matter. But as I told earlier today, if you were to go to my Nona's house, if you came over or any of you came over, guaranteed when she was alive, she would give you a big kiss and a big hug, whether she'd met you before or not. That's just the way she was. She was, she's an old Italian lady. And so would it be okay in the workplace though? No, the rules are different. And so you need to be mindful of that.
What about looking, like an employee's looking at a computer screen, ask you to look at something, you go in behind them to look over their shoulder to look at that?
Okay, I'm going to give that. So that's a good example. So here, turn around here. Put your chair right here. So you're typing. All right. Al's here typing. I don't know if you can, yeah, we're on the video now. So, and Al goes, hey, Mark, I got a problem here. And so I go like this. All right, show me your problem, and I'm looking at it. Anything wrong with this? No. How about this? All right, let me see that problem that you have there. And my arm's over here. I may even put my arm down here. You feel kind of, or I put one on here, right here. I'm not touching you, but what's that problem?
A little creepy.
Little bit close, right? Is there any reason why I needed to go behind Al and just kind of like box him in? No. And so go to the side. And so that's a really good example of, you need to think about how you are dealing with stuff, because that could definitely be deemed intimidating and very uncomfortable as well. So,
What about walking up behind somebody that has their headphones on and scaring them?
what's that? Scaring them. Yeah.
Everybody's got their headphones on, they're in a little world, you touch them on the shoulder.
And that's all. I just go, hey, I don't like to be touched, and so it's just, you just need to be mindful of that. All right, visual, physical. Oops, I touched the wrong button. So visual, derogatory posters, cartoons, sexually oriented photographs. I'm going to get rid of displaying centerfolds because no one's going to bring in. No one does. A lot of the employees, when I say, what is a centerfold? What are you talking about? But you all have these, right? Mm-hmm. You all have data, right? So Jeff, do you have your phone with you? Mm-hmm. Does it have data?
Oh, yeah.
All right, if I ask you to take it out, do you have a search engine? Do you have the little button?
Sure.
For the search engine? Put in www.porn.com.
I don't think that'd be a good appropriate idea.
You almost did it. Good. The response was no. But if you did do that, what's going to come up on the screen? Porn, right? It is on demand 24/7 with these little things. And so, so Al, could you come over here for a sec?
I don't know if I do that.
So,
I'm not bringing my phone.
no, I'm bringing my phone.
My wife sees whatever.
So hey, look at this. Hey Al, check this out here. Or get rid of those, whatever those are. So pretty nice there, and check that out. All right. I have no idea that Jeremy's sitting behind us, right? But Jeremy's looking over, going, "What are they looking at? Oh my goodness!" And these things are game changers, really, because before you used to have to actually bring in a magazine or bring in a pin-up or something like that. No one's going to do that anymore. No one even, some of the younger folks may not even know what they are. But certainly on this phone, and every single one of your employees has a phone that has data on it. I don't know anyone who doesn't in this day and age, or at least 99.9% of them do. And so just need to be very careful of that, because even though that Jeremy isn't part of that, he may see it, and so it's just not okay. All right, the workplace is not a mall, the workplace is not a party, the workplace is work, and the rules are different. We've gone over that. So what are the rules? Recap, quid pro quo, something in exchange for something else. Key legal principles now. Welcome is subjective, reasonable victim standard. So here now, the law is, it's not a reasonable person standard, it's a reasonable victim standard. So the jury instruction is put yourself in the shoes of, and you fill in the blank, what that individual is. A 24-year-old Hispanic female, or a 55-year-old Caucasian male. It depends on whatever it is. So it's a reasonable victim standard. Pervasive pattern. And so a case came out in the last 2 years. It's no defense to a complaint of harassment based upon sex that the alleged harassing conduct was not motivated by a sexual desire. So sex harassment doesn't need to be based upon a sexual desire, so long as it's based upon sex. In this case in particular, dealt with somebody who had a male employee who had effeminate traits, and claiming that he was being treated differently because of his sexual orientation and also because of his sex. And they said, well, it wasn't, the sex case should be dismissed because it wasn't based upon a sexual desire. And the court said, no, didn't matter. So, and then the work environment. Is this the work environment? Training session? Yes. Out in driving to and from your job site, say that there's 2 people in a truck. Is that the work environment? Yes. Is the job site the work environment? Yes. Could potentially, if you go out for beers after work, could that may be the work environment? Well, if assignments are being doled out at that bar or whatever, that arguably could be the work environment. I take a pretty hard stand saying no, it's not mandatory, there's no need to go there, but still you need to be mindful and careful about that. One thing I forgot to talk about, I'll talk about it now, is social media. And you need to be very careful if you're, I don't know if you're Facebook friends with any of your employees or any of your other contemporary supervisors, but stuff that gets posted on Facebook You need to be very mindful of it, and particularly if your Facebook page identifies you as a CHC employee. And anything that you could put out there publicly facing that would be, harmful to CHC's reputation brings it back into the workplace. And so be careful what you put out there, because even though it's off-duty conduct, if it brings itself back into the company or otherwise puts the company in a bad light, there could be an adverse employment action. All right, key legal principles now. Employees, third parties with a business relationship, we've gone over that as well. So the employees are protected. Third parties with a business interest, so if one of another trade out on the job, for example, is the harassing person. Non-sexual conduct, we've gone over that, all the other protected activities. Policy distinctions, you have the zero tolerance policy is what you have, and you do not want to have a content-driven policy, especially now with the new rule changes. So what are your supervisors and managers' obligations? Deterrence, not tolerate, carry out the policy. We've talked about this a lot as far as the deterrence goes and how the rules now have changed. Do not tolerate it at all. Don't be the ostrich and put your head in the sand. Carry out the policies. You have a detailed handbook policy. Confidentiality to an extent, and what that means is what we've talked about, where if an employee comes to you and says, hey, I just want to tell you this, but I don't want you to tell anyone about it, it's confidentiality to an extent, because you have an obligation to do a prompt and thorough investigation. And so you can ask them, well, if what you're about ready to tell me is work related, then I may have an obligation to follow up on whatever you're about ready to say. And if they're about ready to say, you know what, my spouse just ran off with somebody else, they emptied my bank account, and I don't know what to do, I'm just distraught over it, and I need to take a couple days off. Can you keep that information confidential? Absolutely. But that's not what they're going to about ready to say. Maybe they're going to say, you know what, my boss just propositioned me and said that if I don't have sex with him or her, then I'm not going to get a promotion. Can you keep that secret? Or I was out at a job site and somebody was making fun of me because I wear a yarmulke, or because I have a headscarf, or I went in the corner and prayed, or because somebody was saying that I talk with a lisp and they were calling me fag boy. And so, is that okay? Can you just say, all right, I'll make sure, I won't say anything, and I just wanted to get it off my chest. Can you keep that secret? No, because there's an obligation to do a prompt and thorough investigation. Again, notify human resources, and any type of complaint does not have to be in writing, and you can't force them to put it into writing. You have a very well-trained, experienced HR department, and you should use them. And even if you're uncertain about what to do, rely upon them. That's what they're here for. They cannot be the eyes and ears everywhere. You guys are the eyes and ears. And so you need to be mindful and understand and make sure you keep it zero tolerance. Sensitivity and perceptions and feelings of others, and then no retaliation, which means is that, and the thing about retaliation that you need to be mindful of is that the United States Supreme Court, which is a very conservative, or not very, pretty conservative now, it's getting more conservative, but in the last 15 years, there's been about 7 retaliation cases that's gone in front of them. Maybe 20 years now. The first one was back in '99. Every single one of them, the Supreme Court has ruled in favor of the employee. And so what has happened is the bar for retaliation keeps going lower and lower and lower. And so the bottom line is, if anybody makes any type of complaint, that you can't treat them differently as a result of it. And it kind of goes and dovetails into, keep it business related. That's a good place to think about. Non-discriminatory, legitimate business reason. So, supervisors are obligated to report sexual harassment, discrimination, and retaliation when they become aware of it. What should a supervisor do if he or she is personally accused of the harassment? What should you do? Go to HR as well too. You will be interviewed as part of the process as well. And the HR would likely tell you Don't speak to others about it because we're conducting an investigation. The employer's obligation, take all reasonable steps. You have a policy, you're doing the training and the deterrent, prompt and thorough investigation, and appropriate corrective action. And the employer, what is appropriate corrective action? It could be, hey, Mark, you stand too close to individuals and you touch them, you need to stop that. Okay, I'll stop. I get it. Is that appropriate corrective action? Yeah, it may be a verbal warning, it may be a final warning, it may be a termination. Who knows? There's no progressive discipline. They'll look at it on a case-by-case situation. So, we're not going to go over each and every one of these, but these are just jokes about women, racial stereotypes, jokes about someone's sex life, etc. And so those are all going the wrong direction. Who is liable? So the employers are strictly liable for any damages. We've talked about that. That is strict liability. There is also personal liability. We've talked about that as well too. And so, see this? This is a caption. This is a complaint. This is what happens when companies get sued. And so see there? These are the attorneys for the defendants, and we're answering to a complaint. All right, and this is in Alameda, and unfortunately, the company will be sued. But see there too, Miss Manager or Mr. Manager. If you are the alleged harasser, you will be named in the lawsuit. And the company has no duty to defend or indemnify you because the company has a zero tolerance policy set forth in your handbook. And so any type of harassment or discrimination is outside the normal course and scope of employment. And so there you are being sued. And this is the do you like your house law, because they can go after you individually. And here in California, especially in the Bay Area, housing is still on the up. And so this is why you want to make sure that you are not harassing, discriminating, or behaving in any types of behaviors that would potentially go down and find your name here on a complaint. You want to stay away from that. So if you feel that you're subject to this, what do? Tell them to stop. And this is what I told all of your employees to do. They should feel emboldened to say, hey, look, stop it, knock it off. But a lot of times individuals do not feel comfortable confronting the individual. And so what do? And what did I tell them? They can report it to HR, they can go to Bob, they can go to a supervisor, they can go to another supervisor. So we are not going to go over all of the, because you guys had so many great questions, but what I am going to do is go over the quiz part of it, and then we'll get out of here. And so, but everything that on the question, the work pattern here, we've already gone over this. So, if you turn to page 4 of this, we'll go through the quiz and then we'll be done. So, first, employees can be individually liable for unlawful harassment. True or false?
True.
True. If an employee participates in conduct based upon a protected category, example, a person makes sexual jokes, the employee cannot make a successful harassment claim. False. In California, an employer is normally liable for actions of its supervisors when unlawfully harassing an employee. True. Can a company be liable when its vendor unlawfully harasses an employee? Yes. Can mere pinups of scantily clad women or men in the workplace lead to a successful sexual harassment case? Yes. Can an employee violate a no harassment policy even if she did not intend to be offensive?
No.
Yes, remember it's a reasonable victim standard. You may think you're the funniest jokester in the world, but it doesn't matter. Reasonable victim. An individual must be fired before pursuing a claim of unlawful harassment. False. If an employee initiates a welcome consensual relationship with a supervisor, he or she can no longer claim sexual harassment. False, especially when it ends. Can an employee who is not the direct object of the conduct make a claim for unlawful harassment? Yes. Can an employee who resigns cannot later argue that his or her termination was due to harassment? False. Constructive discharge, we went over that. A claim of harassment is brought to you by an employee. The employee asks you not to do anything. You agree. Can he or she later bring a lawsuit?
Yes.
Yep. Can sexual harassment claims be filed by men as well as women?
Yes.
Yep. Can sexual harassment claims be filed if a man harasses another man or a woman harasses another woman?
Yes.
Yes. Do the employer's responsibilities differ depending on who commits or who is accused of committing unlawful harassment?
No.
No. Do the standards vary from one industry to another? No, they do not. And so we hear this a lot in some of the trades. Oh, but this is the construction industry. This is we're a man's world. Forget about that. Or restaurants, the kitchens, a lot gets said in the kitchens. Nope, the law is very clear. It doesn't matter what industry you're in. Does it matter if the person who's accused of harassment is merely engaged in conduct that is part of his or her culture or background? Nope. Remember I said, you know what, I'm Italian. I like to touch people. Doesn't matter.
You skipped number 16.
Oh, I skipped 16. Are there any exemptions from the law? No. 18, can an employer always avoid liability by simply disciplining or terminating an employee who's committed sexual harassment? The answer to that is no. And that is why we're having this training and why we're turning the ship here now. And so just by firing somebody does not necessarily avoid the liability. Must all complaints of harassment be kept strictly confidential?
Yes.
No, remember, we talked about that. You can't promise absolute confidentiality because say that you bring a claim of harassment, right? And you say that, you know what, Al witnessed it and Jeremy witnessed it and Tim witnessed it. And so and you tell the employee you're going to keep it absolutely confidential, and then you go to Donna and say, I told them I'd keep it absolutely confidential. You can't do that. Why? There's an obligation to do a prompt and thorough investigation, and you got to talk to Tim, Al, and Jeremy. And so confidentiality to an extent. And so when I talk to Al, or not when Donna talks to Al, she'll tell him, hey, look, we're conducting a confidential investigation, and that you can't talk to anybody about this, or you're subject to disciplinary action up to and including termination. Do you understand the rules? So you can cloak it in confidentiality. But
within the investigation.
Exactly, but you can't promise absolute confidentiality because you have to do an investigation. And typically there's no such thing as a purely total confidential investigation because you got to talk to somebody because there's going to be witnesses. Sometimes there's no witnesses, but you're going to have to at least talk to the accused and the alleged victim. All right. Can employees be disciplined for filing false claims? Yes. Must the victims of harassment always confront the accused harasser directly before reporting the matter to an official of the employer? Nope. Should supervisors address the issue of possible retaliation at the same time they investigate a claim of harassment? The answer to that, should supervisors, should employers? The answer to that is yes. You're always reminding the employees of the actually accused, the victim, and the witnesses that they are free to speak because we have very strong no retaliation rules. Should the subject of retaliation be raised with the person who registers the complaint and the accused individual? And the answer to that is yes as well. So, actually I did it in about 2 hours because we did start a little bit late. And so, most important, make sure that you do the sign-in sheet because we're going to get certificates to show that you did the 2 hours. You guys are now good for another 2 years because that didn't change as well. The most important takeaway, and you can see we emphasized it a lot, is that the rules have really, they've changed. And so what may have been okay behaviors in the past really need to be changed going forward. And it may be it's difficult because certain types of behaviors are hard to change. But the bottom line is this, is that you still, as Bob said, I want to emphasize that you guys are the managers, and it doesn't mean now you need to be a soft manager or let everybody get away with this and that because you're walking on eggshells because you're worried about how the person is going to react or respond to you. So long as that you're consistent with your management style or even inconsistent, because there may be an individual that really needs to be hands-on, where you may have other individuals that, you know what, that individual, you're confident that they're able to do it without being hands-on. And so are you treating somebody differently? Yeah. Why? Because you have a legitimate non-discriminatory reason for doing it because they keep making mistakes. And I need to make sure that they're on it, and I need to make sure that they're on task. And or they always miss deadlines, and so I need to follow up with them, or the other person doesn't, so long as you have a legitimate, non-discriminatory business reason. All right, so with that, thank you all. And,